Thank you so much, Kumu Pueo. We're so grateful to you for traveling to Oahu and opening up the space for this really important event. Thank you so much. Aloha and welcome everyone to the University of Hawaiʻi Law Review Spring 2024 Symposium titled E Hoʻi Nani, Chief Justice Richardson's Public Trust Legacy and Envisioning the Future of I am Leeyannah Armaine Santos, one of the co-editors-in-chief of the University of Hawaiʻi Law Review, Volume 46. On behalf of the University of Hawaiʻi Law Review, thank you so much for joining us today. Today's symposium will both honor Chief Justice Richardson's legacy in water rights and discuss the power and potential of the public trust to shape Hawaii's future, especially in light of Maui's recovery from the devastating August 2023 wildfires. Before we begin the panels, we would like to thank everyone who helped make this symposium possible. First, we would like to thank the deans and their administrative assistants for their support and assistance in planning today's event. Thank you to Dean Nelson and her administrative assistant, Christy Shiraki. Thank you to Dean Murkay and his administrative assistant, Heather Young. And thank you to Dean Nakamura and her administrative assistant, Tracy Sir. We would also like to thank those who have sponsored the Law Review in support of this endeavor: Hawaii Community Foundation, Kamehameha Schools, the University of Hawaii Office of Student Equity, Excellence, and Diversity, the Kahuliao Center for Native Hawaiian Excellence, the John Van Dyke Foundation, our very own Student Bar Association, and the William S. Richardson School of Law. We would also like to thank our faculty advisors, Professors Justin Levinson and Miyoko Pettit-Toledo, for their wisdom and guidance as we planned this timely event, our faculty support specialist, Julie Suenaga, for her tireless work and commitment to supporting our journal, and to our Volume 46 editorial board and staff writers for their assistance with today's event. We especially want to extend our gratitude to our symposium committee made up of dedicated Law Review members who have devoted their time and energy into helping us plan this magnificent symposium. We could not have done this without you. Today, we are also honored to be joined by Dean Camille Nelson, who leads the William S. Richardson School of Law. Dean Camille Nelson has long been an outstanding member of the legal community. Prior to her appointment as the Dean of the University of Hawaii at Manoa, William S. Richardson School of Law in 2020, Dean Nelson served as Dean of American University Washington College of Law and as Dean of Suffolk University Law School in Boston. She was also a professor of law at the Maurice A. Dean School of Law at Hofstra University, a Dean Scholar in Residence and visiting professor of law at Washington University and St. Louis School of Law, and a professor of law at St. Louis University School of Law, where she was recognized as both Professor of the Year and with a University Faculty Excellence Award. She is an elected member of the American Law Institute. She has taught contracts, torts, criminal law, comparative criminal law, transnational law, critical race theory, criminal procedure, and professional responsibility at a number of law schools in Europe, Canada, and across the United States. We are incredibly grateful for the deans and the law school's continued support of the Law Review and for their contribution to this year's Law Review Symposium. To begin this year's symposium, we have asked Dean Nelson to share welcome remarks. Please join me in welcoming Dean Camille Nelson.
Thank you, Leeyannah. Leeyannah is one of our absolutely terrific student leaders and the co-editor-in-chief of the Law Review. I appreciate all of the hard work undertaken by the Law Review students in planning and organizing this symposium. Aloha. Aloha. On behalf of the William S. Richardson School of Law, I am deeply honored to welcome you to the University of Hawaiʻi Law Review Symposium today. Good morning and welcome to our students, to our staff, and to our professors. Greetings also to the justices, judges, attorneys, legal professionals, community members, and other wonderful parts of our ohana for joining us today, both in person and on Zoom. I hope those of you on Zoom can hear okay. Everything's all right with the Zoom transmission? Yes? Great. And thank you also to our speakers and moderators for joining us today. We greatly appreciate you for contributing your time and your inspiring manoa to this important conversation. Let me correct, mana'o. I would like to warmly welcome our panelists and guests from Maui, Komohana, who will be joining us both in person and online today. And finally, I'd like to acknowledge there are several judges and justices who will be with us in person or online throughout today. I want to acknowledge that Chief Justice Mark Rechtenwald will be joining us. I see you, Justice Todd Edens, welcome. Lisa Ganoza, Justice Ganoza will be joining us, I believe, online later, as will Justice Vladimir Devins, and I believe Judge Barbara Beebe Richardson will be with us online as well. Thank you all. Thank you all in the room for being here as well today. This symposium highlights the legacy of Chief Justice Richardson and the future of water in Hawaii. It's an important year. We're highlighting these important topics in a year in which we are celebrating not one but two momentous anniversaries. First, the 50th anniversary of the law school founded by Chief Justice Richardson. He approached the founding of our law school from the perspective of equity, with the goal that the state of Hawaii, too, should offer quality legal education, and the dream that this access to education would lead to a more just and equitable society for all. It has also been 50 years since the Richardson Court first affirmed water rights in Hawaii through the Public Trust Doctrine in the landmark case McBryde versus Robinson. So, in many ways, Chief Justice Richardson's vision guides this symposium. In doing so, C.J. Richardson embraced an inclusive, equity-seeking approach, one which sought to recenter Native Hawaiian customary law in our modern jurisprudence. There is perhaps no greater example of this than the Public Trust Doctrine and the jurisprudence underwriting it, through which C.J. Richardson set forth the fundamental framework that has since shaped the landscape of water law in Hawaii. Now, this symposium marks these 5 decades and contemplates the next 50 years. We acknowledge and celebrate the community leaders, the advocates, the students, and those within our legal community who continue to further this vision set forth by C.J. Richardson through their work and their commitments. We are confident that through this convergence of expertise and powerful voices, solutions for the future, equitable and lasting solutions, will emerge. As Hawaii's only law school, Richardson Law is at the center of this epicenter of intersecting local, national, and global discourse. Through their scholarship and work in communities, our faculty, students, and alumni remain at the forefront of transformative justice movements for communities here in Hawaii and beyond. Today's event centers on the unique struggle for justice for the people of Maui. However, the consequential discussions that are the focus of today's program will have important implications for water management and policy across all of Hawaii and may well serve as a model beyond our borders. In closing, I would like to extend a special thank you to the Law Review Symposium Committee, led by Editors-in-Chief Leeyannah Santos and Drew Hara, as well as Executive Editors Kalei Akau and Hannah Tom. We appreciate your hard work and evocation of Chief Justice Richardson's vision in the centering of this symposium. These student editors have dedicated countless hours over the last several months to the creation of this multidisciplinary forum highlighting the complex legal landscape of water issues in Hawaii, and they have done so with incredible grace, integrity, and fortitude. They have put together a phenomenal program, and I thank you all for being here to engage with these very important and timely conversations. Now I'm going to ask Drew to come forth to the podium to share some more information about today's symposium. Thank you all. Enjoy the day.
Aloha again. Mahalo to everyone for joining us today, and mahalo to Dean Nelson for those wonderful opening remarks. This symposium and the work of the Law Review would not be possible without the support of Dean Nelson and those other in the faculties who have dedicated themselves to making Richardson a truly unique and supportive environment for learning. Just some housekeeping about the program today for those attorneys in attendance who are seeking CLE credit. Please make sure that you've checked in if you're here in person with our registration team outside and that you check out before you leave. And for all of you, if you're looking for CLE credit, whether in person or online, just follow up with an email to Hawaiʻi Law Review to make sure that you get your certificates. Our program today, we're going to begin with our first panel immediately after these remarks, as soon as possible. And then we'll take a short break, reconvene around 11 a.m. for panel number 2. At 12:30, we're going to take a 1-hour break for lunch. We'll come back for our afternoon session starting at 1:30 with panel number 3, and our final panel will begin at 3 p.m. So just some more information about the Law Review's intentions in holding this event for us today. In planning the symposium and given the timing, we knew that we wanted to honor Chief Justice Richardson's legacy as a jurist and an educator. That decision was easy for us. The hard part was deciding which part of his legacy to highlight, because as many of you know, whenever you start down the path of trying to understand contemporary law in Hawaii, almost all roads lead to CJ. We ultimately chose to spotlight CJ's jurisprudence on the public trust with a focus on water law. As we all know in Hawaii, e ola i ka wai, water is life. And this ubiquity requires that everyone of all walks of life be invested in the conservation, protection, and equitable distribution of water. For our Law Review Board, water law is a topic where many of our individual fields of study converge, as it implicates environmental law, Native Hawaiian rights, and social and restorative justice. As many of you may know, law and the call for justice develop in real time. Now more than ever, our communities are alert to the fact that we need to pay serious attention to how our water resources are being managed and protected. On Oahu, we are dealing with the crisis at Red Hill, and on Maui, which has long been ground zero for these struggles over water, the fires that tore through that island last August have revealed some harsh truths about historical mismanagement of water, and about how the historical mismanagement of water has left our communities vulnerable to the impacts of climate change. As we continue to plan today's symposium and continue to delve deeper into the issues and the interests at stake, we began to understand the importance of the topic that we had decided to cover, and to realize that struggles over water on Maui and across our state are in reality a battle for the soul of Hawaii. Someone who may or may not be in this room recently reiterated for me that law is just one instrument for justice. In this spirit, our symposium departs from the formal tradition of limiting the conversation to the voices of legal scholars alone. In an earnest effort to find lasting and equitable solutions, our symposium brings lawyers, judges, community leaders, storytellers, and other water experts together in conversation to discuss the most pressing issues around water law today, with a particular focus on how water management and the application of the public trust will be critical to Maui Komohana's recovery from the fires last summer. We have a wonderful program for you today. Some of these conversations may be difficult, so we ask all of our participants and all of you in the audience to please honor our tradition at Richardson of kapu aloha. As CJ would say, we need to be hard on the issues, but easy on the people, always. Now, to speak more about CJ Richardson and his tremendous legacy is someone who's much more qualified than I am. It's my great honor to welcome the moderator of today's first panel, Professor Melody Kapili Aloha Mackenzie.
Mahalo nui. I wanted to talk just a little bit more generally about C.J. Richardson. 45 years ago, Chief Justice William S. Richardson actually wrote the introduction to the very first issue of the Law Review. He shared that in early Hawaii, when a skillful piece of work was completed, the finished product was blessed. And during that blessing, the words that were often said were "Homai ka'ike nui, homai ka'ike iki," which is grant knowledge of the great things and of the little things. Ka'ike nui referred to the knowledge of the work as a whole, while ka'ike iki referred to knowledge of the details of the materials and techniques which a good artisan, a good craftsperson, should thoroughly understand. C.J. Richardson was just such a craftsman. As a jurist, in his establishment of our law school, and in his role in the community, and because of C.J. Richardson's background, his humble beginnings, his long journey to attend law school in Cleveland, his service in World War II, and his desire to change the second-class status of Hawaii's people, C.J. committed himself to social justice by changing Hawaii's political and government structure. He did so with attention to both the details, ka'ike iki, and the larger vision, ka'ike nui. C.J. Richardson consistently encouraged Native Hawaiians and other underrepresented groups to work within the legal system to make positive change for all of Hawaii's people. And nowhere is that wisdom expressed more clearly when we're with more eloquence and force than in the opinions that he wrote over the course of his 16-year tenure as Chief Justice of the Hawaiʻi Supreme Court. His opinions reflected his humble background, his commitment to a more open society with equal opportunity for Hawaii's multi-ethnic population, and his strong belief in looking to Hawaii's rich past, Kawama Hope, yesterday, as a source of today's law and to guide us going forward, Kawamamua. In 1966, as he was beginning his tenure on the Supreme Court, C.J. reflected on his new role as a judge. He said, "The man who is Chief Justice must balance the rules of the past to conform with the state of society today. He must bring the old rules in line with modern times. He must remember that those rules were made under a different structure. He must live in the past, but not only the past. He must adopt the fundamental principles of the past and bring them into focus with the present. And in Hawaii, the present, like the past, is a time of migration. It's a time of change." For C.J. Richardson, the past included more than the principles of Anglo-American law. It also included the principles of Hawaiian custom and tradition. And for him, the past, the present, and the future all encompass the concern for the common person and for the dispossessed and disadvantaged. C.J. understood and embraced his responsibility. He knew that he and his fellow jurists had the opportunity to make major changes, and he welcomed that opportunity. Working closely with other members of the court, C.J. helped to reincorporate Native Hawaiian tradition and custom into state law and expanded public rights. His decisions show his effort in balancing competing factors, the past and the future, Western law and Hawaiian law and traditions, and the right of the individual and the rights of the collective, and public as well as private interests. All times, this new yet old way of thinking was criticized, but it has become recognized now as an enlightened approach for our distinctive multicultural homeland. Professor Williamson Chang will discuss CJ's water cases in detail in his presentation this morning. I just wanted to super briefly mention a few of C.J. Richardson's other groundbreaking cases. He has identified In re Ashford as a decision of which he was most proud. And in Ashford, the court determined that under ancient Hawaiian tradition, custom, and usage, seaward boundaries described as makekai, or along the ocean, are located along the upper reach of the wash of the waves. And Ashford was followed by two other major cases, County of Hawaii versus Sotomora and In re Sanborn, reaffirming that the public ownership and usage of Hawaii's beaches. Another landmark case was State v. Zimri, and C.J. Richardson held that the lands created by lava extensions are owned by the state of Hawaii. He could find no prior customary issues about this or even any judicial precedent. He reasoned that equity and sound public policy demand that such land inure to the benefit of all the people of Hawaii, in whose behalf the government acts as trustee. Thus, the court accepted that trust standard as applying to all public lands. CJ's 1982 decision in Kalipi v. Hawaiian Trust Company on Native Hawaiian gathering rights broke new ground. Recognizing that such rights are protected by several different sources of Hawaiʻi law, the court determined that lawful residents of an ahupua'a may, for the purpose of practicing Native Hawaiian customs and tradition, enter undeveloped land within the ahupua'a to gather certain items. The court also held that pursuant to the newly enacted provision of the Hawaii State Constitution, courts are obligated to preserve and enforce such traditional rights. There's more to the Kalipi case, but I don't want to get us too off track. The establishment of the law school in 1973 was obviously one of CJ's crowning achievements, determined that everyone in Hawaii should have the opportunity to obtain an excellent legal education. CJ led an uphill battle to form this law school. He solicited and allied himself with advocates in Hawaii and across the US, and he was successful eventually in persuading the University of Hawaii, then the legislature, and ultimately the downtown bar to establish and support the law school. The first classes were held in the portable classrooms down in the quarry. They're still there today. There was no restroom. I was in that first class. I think I forgot to mention that. And so we had to go across the street to the dance rooms to go to the bathroom. It was dusty and it was noisy, and there would be layers of thick brown dust on all of our books and papers if we left them for any length of time. There were 53 students in that first class, including future Governor John Waihee, Abigail Madrid Shaw, who was one of the first women of Filipino descent to actually practice in Hawaii, and the current Senator Carol Fukunaga. She's still a state senator. And then 4 of CJ's law clerks. Professor Mari Matsuda, who graduated in the class of 80 and so went to school in the quarry, said of CJ, he was running the entire judicial system of Hawaii and writing decisions that would change the course of history. Yet he took the time to come to our parties, even if a party was just some beer and pipi kaula on the steps looking out over the muddy parking lot. So, officially named after CJ in 1983, CJ's ideals continue to shape the law school even today. Not only did CJ Richardson handle the logistical work of forming and sustaining this law school, he maintained an office at the school, and he continued to participate in the school's development, supporting especially the Native Hawaiian law, elder law, and ulu lehua programs. Year after year, students would see CJ Richardson in their classes, at student events, at graduations, at ete bowl games. At the law school, students would often come to his office to talk to him, to get his advice, or even just to sit in his presence. And he told me that he just loved that. Today, the Richardson Law School is one of the most ethnically diverse law schools in the country. And because of CJ's perseverance, over 3,300 of our school's graduates, many from underrepresented minority and indigenous Hawaiian and Pacific communities, are practicing law, holding elected office, teaching law, serving in the judiciary, leading community service organizations in Hawaii and throughout the Pacific. Chief Justice William S. Richardson, the visionary who looked to ancestral wisdom and practice to chart the way forward for Hawaii, the one who brought life to this law school, the law school that now bears his name, and the man who, with his gentle smile and modest demeanor, won the hearts and loyalty of so many of us. He ensured that interpreting the law, the Hawaiʻi Supreme Court looked to and addressed the small details of each case, while understanding the ike nui, the larger impact and greater meaning of each case. How would the case advance justice, restore Hawaii to our streams and lo'ikalo, ensure that Hawaii's native people are able to continue to practice and grow their culture, and make certain that all people of Hawaii benefit from the wise use of our natural resources? C.J. Richardson understood and embraced the importance and value of both ka'ike nui and ke'ike iki. And as a result, all of us have benefited from C.J.'s attention to the small details and his commitment to bringing those details together to reach ka'ike nui, the greater vision of justice for Hawaii and beyond. Mahalo nui. I want to now turn to our very first panel and invite our panelists to please come forward. And as they do so, I will do a quick introduction of them. Okay. Professor Williamson B.C. Chang will be speaking first. He'll be doing a little kind of overview of our major cases, McBryde, and then the Robinson case. He was personally involved in shaping the Public Trust Doctrine during the Richardson Court era, and served as a special counsel to the Hawaii State Judiciary before the Ninth Circuit in Robinson versus Ariyoshi. As you all know, he's been at the law school since 1976. Can you imagine that? So I want to just introduce Bill. I will introduce Justice Richard Pollack and Isaac Moriwaki after Bill does his discussion. Okay? Thank you, Bill.
Good morning and aloha. I have the honor of shaping the big picture of the water rights litigation that started in 1954 for the Hawaiʻi Supreme Court. I would just say it's time to celebrate both the life and work of Chief Justice Richardson. He cared very much about two things in his public life: his judicial opinions on state property law and the law school. It is my great honor to have been of service in both. As was pointed out, my association with the law school goes back to 1976. My association with Chief Justice Richardson goes back to 1977, when I was appointed, as she mentioned, to be a special Deputy Attorney General to assist the court in bringing its views before federal courts in the Robinson case, in the Sotomayor case, and the Zimring case that Melody just laid out for you. In each of these, he expanded the rights of the public, and as such, private property owners lost some of their rights. And each of these opinions were attacked in what was called a judicial taking. The court would take their rights. The dispute over Robinson versus Ariyoshi and McBryde versus Robinson, and they're really the same case, as I'll explain, begins long before, in 1959, in a court on the island of Kauai over the Hanapepe River. Two sugar companies, McBryde and Olakele, were fighting for the water. And at that time, the law was that the water could be owned as private property. It could be bought and sold. It was a commodity. One of them was going to win. The other was going to lose. The trial court, the Circuit Court of Kauai, went over the case very carefully. 3,000 pages of documents were filed. The court allocated the water between the two fighting sugar companies. The state of Hawaii claimed it owned water, and some small owners claimed to have pertinent water rights. And this case was unsatisfactory to one of the parties, so they appealed it to the Hawaii Supreme Court. That court arrived, that decision, that case arrived in the Supreme Court in 1953. And it was the first water rights case for the new court. And I call it a new Supreme Court because it was a very different court from the courts that were composed of justices in the territorial period. And we'll go into that on the panel. I might go into some of it here. But the issue was who owned water. And the court, now composed mostly of people of color, and Bernard Levinson, who was a very liberal and astute judge. For the first time, the court was composed of people of color, as Chief Justice Richardson, Bert Kobayashi, Justice Abe, and Justice Maramoto were in the court. These justices were men of a different background than the earlier justices. And led by Chief Justice Richardson and Justice Abe, the court announced that the water was not owned by anybody except the state. That these parties who were claiming it was theirs had gotten it wrong, that it was really belonging to the state. In that sense, Justice Abe used the term state ownership. He also declared that the waters could not be removed from the valleys. So the decision was attacked as a taking of the private property of the sugar companies who came before the court. Before the decision, they had the water as private property. After the decision, they didn't. Water was a thing compared to public trusts. So the question was, what was the Supreme Court and the sugar companies going to do? The McBryde case was a fight, as I said, about water rights. The Supreme Court declared the state to be the owner of water, and in so doing, he rejected years and years of reliance on three precedents from the time of the territory, which declared that water was a commodity. The first thing the sugar companies did in response to the motion was in response to the decision, was to file for reconsideration. The court granted a limited amount of reconsideration and allowed them to argue, but not the constitutional issues. At the hearing, the court reaffirmed its initial McBryde decision in all respects. The sugar companies filed a petition in the United States Supreme Court, and the United States Supreme Court just ignored it. So normally that would be the end of the litigation. The court was final in its decision. Instead, the sugar companies joined forces and brought a new action in the U.S. District Court for the District of Hawaii, alleging that the state, through its high court, had taken the property without just compensation. The sugar companies alleged that the Richardson court had changed the law, upsetting the rights of ownership of the parties, and their civil rights have been violated. The case went to trial, and Judge Pence ruled in their favor, enjoined the enforcement of the Supreme Court decision, and concluded that the civil rights of the parties have been violated. At that time, I received a grant to study Native Hawaiian water rights, and in doing so, I studied the McBryde case, and I thought things could be better argued, so I went to the Attorney General. He told me to see the Chief Justice, and the Chief Justice appointed me as special counsel to represent the court in the litigation that was in federal court. I studied a water rights course at the law school, and the water rights course I started was composed of very dedicated law students, very brilliant law students, and we came up with some ideas that were going to help in the litigation. We came up with the idea that the state ownership of water was really better understood as a public trust, relating back to the ancient Hawaiian water rights where no one owned it. It was sacred, it was special, and the ownership of water was not a thing. I raised it before the Supreme Court. The Supreme Court was confused. What was the real meaning of the Hawaii Supreme Court? And they certified questions back to the the Hawaii Supreme Court. I introduced the idea of a public trust, which came from my class, and the Ninth Circuit said, well, we're going to find out what the court really meant. And in a beautiful decision, Robinson versus Ariyoshi, which Justice Pollock has said is true poetry, the Supreme Court affirmed that it was referring to the Public Trust Doctrine when it declared that the state owned water. In Robinson, the Hawaiʻi Supreme Court replied to 6 certified questions relating to McBryde. It strongly affirmed the principles outlined in McBryde on the Public Trust Doctrine in both traditional and Hawaiian and modern usage. The court explained that the decision clarified ambiguous law rather than departing from settled principles. Under these circumstances, it was appropriate for the court to review the entire history of Kanaka Maoli water usage and settle on the public trust as the most appropriate doctrine for water rights. And in doing so, they largely eliminated the idea that the water had been taken. The public trust didn't belong to the state. It was the state's trust to distribute it wisely. Judge Pence was nevertheless reluctant. It went to the United States Supreme Court. He was reluctant to abide by the decision. The United States Supreme Court ruled in our favor that it was a public trust. It was remanded to Judge Pence, and he refused to dismiss the complaint. The case went up to the Ninth Circuit again. They ordered Judge Pence to dismiss it. He did. That's where we are today. The public trust is the law of water rights. The public trust was turned into a tremendous tool for preserving natural resources. Thank you.
That was wonderful, Professor Chang. Thank you so much. I think everybody has to actually put on their mics. Just hold it? Okay, just hold it. I wanted to introduce Justice Pollock. After a number of years as a circuit court, he served as an associate justice of the Hawaiʻi Supreme Court from 2012 until his retirement in 2020. And throughout his tenure in the court, Justice Pollock authored over 150 published opinions, including the landmark public trust decisions, Kauai Springs v. Planning Commission, and I'm sure that's going to be discussed in later panels, and then Ching v. Case, another major decision from the perspective of the public land trust land, INA. And as Chief Justice Richardson proclaimed in 2020 on Justice Pollock's retirement, Justice Pollock shaped the court's jurisprudence in areas including public trust resources and the environment, criminal procedure, evidence, and public access to governmental proceedings. So thank you so much for being with us today, Justice Pollock. I'd also like to introduce Isaac Murawaki. He's a 1998 graduate of our law school and the managing attorney for the Mid-Pacific Office of Earth Justice, the leading public interest environmental law firm in the United States. Isaac's legal advocacy to protect Hawaii's public trust resources includes his work over the last 20 years to reverse sugar plantation water diversions and restore flows for local and Native Hawaiian communities in Navaeha. As Professor Kapua-Sproat has shared, Isaac knows C.J. Richardson's water law jurisprudence on a spiritual level. So please join me in welcoming all 3 of our panelists. I guess I'm going to start off with asking both Isaac and Justice Pollock, did you have anything that you wanted to add to what Professor Chang said this morning on Robinson or McBryde?
Is it on? Yeah. I think I'm not going to add too much. I think Professor Chang really set forth a nice summary of the case. I think one of the things, though, that is so remarkable about that case, and I do plead guilty about saying that the case, I have described the case as being, poetic. And it is really, and I think the students I've had probably get a little bit tired because I quote so many passages out of it, but it is just beautiful. It really is. And, you know, if you haven't read the opinion, you really, really should. But one of the most remarkable aspects about that opinion and its forerunner, of course, and why we're here today, is that you had two plantations arguing over who owns the water, and the decision, of course, was neither of you. Think about how remarkable. I mean, courts get criticized sometimes for invoking plain error, essentially saying this issue hasn't been raised previously. The court even went a step beyond plain error because it said it wasn't only the issue, but the two parties that were arguing, the court said neither of you win. It's the states. And that's really, really been a remarkable decision, and it really set in the motion why we're all here. And it's just, it led to everything that we're going to talk about today, and it's going to be raised in all the other panels.
Good morning, everyone. So privileged to be part of this panel. I'm wearing a mask. It's not COVID, but it's still junk. But it's giving me this rich baritone voice this morning, so I just want to echo that, first of all, it's cosmic that 50 years from the founding of the law school, 50 years from the McBryde decision. How cosmic is that? And then likewise, agree with Justice Pollack that we take all these things for granted today. We take the law school for granted. We take water being a public trust for granted and not private property. And to think back of that spirit of the times in this new court, in this brand new state, is there any other decisions, whether in this court and anywhere else, frankly, that you can think of where, like Professor Chang said, one day the plantations had it, the next day they did it? Is there any other decision that registers this high on the Richter scale of judicial action and judicial principle? So yeah, I think we really owe a great debt to both C.J. Richardson and the institution of the Hawaiʻi Supreme Court in general.
Thank you. I wanted to ask how then, okay, so the court recognized that, oh no, this is not owned by either party. It is, in fact, quote, owned or in trust, held by the state. How did they ground that in Hawaiian tradition and custom? And I think I'll start with you, Isaac.
Okay, well, I don't quite know what Kapua meant when she said I have a spiritual connection to it, but along those lines, I will read the scripture. So in preparation for this panel, I actually went back and read both the McBryde decision and the Robinson decision word for word. And it's amazing how decades later, fresh eyes, you just find stuff in there, or new light flashes, new mini epiphanies. And so first, your question, Professor McKenzie. He went back, or it was Justice Abe, mind you, but C.J. Richardson was part of that majority opinion. And the court went back to the original principles of that Mahele process. And in there is a specific mention of sovereign prerogatives of the king. And one of them was to encourage and even to enforce the usufruct of lands for the common good. So this is grounded in ancient Hawaiian custom, but also in the very first laws of the Hawaiian kingdom, of the sovereign Hawaiian kingdom. And then they pivoted to this statement. We believe that the right to water is one of the most important usufruct of lands. Usufruct is a fancy legal term for use, or the ability to use something. Usufruct of lands, and it appears clear to us that by the foregoing limitation, the right to water was specifically and definitely reserved for the people of Hawaii for their common good in all of the land grants. Therefore, the right to water was not intended to be, could not be, and was not transferred to the awardee, and the ownership of water in natural watercourses, streams, and rivers remained in the people of Hawaii for their common good. So saith the Hawaiʻi Supreme Court.
That is an amazing quote. Thank you so much for calling it to our attention. Professor Chang, did you have something further you wanted to add? Looks like you wanted to talk.
Yes. Is this on? I'll borrow yours. I hope I don't catch what you have. Well, one of the most important things was, if you wanted to look at the opinion, is footnote 25. And you have to understand that the water rights belonged to the people up until the overthrow. After the overthrow, the court had changed. People in the court were part of the revolution, the overthrow. They were also, the court was dominated by sugar lawyers, and the situation was sugar was king, and the Big Five ruled Hawaii. And so the sugar companies began to influence the law to create this ownership of water. So the social revolution by which the CJ became Chief Justice had a lot to do with the fact that the court overturned the years of ownership of water. And if you want to look at footnote 25, I think that's very poetic. And I think Justice Pollock admires it. It speaks to the four regimes in which there's law in Hawaii, and that the law from the territorial period came from a period when Hawaii did not have self-governance. The governor was appointed by the president. People didn't elect the governor. The president appointed the justices. That change of statehood, the governor would appoint the justices, and he was the person that now, because of the change in political way we selected the governor, he represented the people much more than before.
Thank you so much. The footnote 25, I think that Professor Chang is referring to, is in the Robinson case, not the McBryde case. But I know.
I have it right here too.
Okay, could you read it to us?
Real quick, the highlights. But so recall the context, right? Because the plantations take the state of Hawaii to federal court alleging an unconstitutional taking of their property in water. It goes to the Ninth Circuit. The Ninth Circuit certifies some questions to the Hawaiʻi Supreme Court. Tell us more about what you were thinking about this thing. And so there's this footnote dropped in the middle of that. And they say, all this previous law about water being private property was during the territorial period when the judiciary was not a product of local sovereignty. Okay? And then he goes on to say, and this was authored by C.J. Richardson, this Robinson opinion. It took place during a period when the resources of our land were subject to an authority which did not directly represent Hawaii's people, and that the most recent pronouncements on the subject, that is the Richardson Court, arise more immediately from the authority of those who will forever be affected by it. I mean, how boss is that? When I read this thing in law school, I was, as a law student, punching the air. But this is one of my big mini epiphanies, though, that the Richardson Court went back to the sovereign prerogatives, right? And he's talking about sovereignty here in this footnote. And really, so it's a statement of the Hawaiian word ea. It's in our model, ika uamau ke ea ika aina. And this was about ke ea o ka wai. And so it really was CJ's real move to decolonize water law in Hawaii.
Mahalo. That's great. Justice Pollock, do you have anything you want to add to that?
Yes. There's something else that the Chief Justice did in that opinion. And he was almost, I think he knew what was coming, but he couldn't do it all in this opinion. And he distinguishes what I call the Western Public Trust Doctrine, which is essentially protection of navigable waters, where it's a restraint sort of on the sovereign powers to protect navigable waters. And what he said, I think the exact word was, it was akin. Our public trust doctrine from the kingdom was akin to the Western public trust doctrine, but not the same thing. And the difference is the king had reserved the water for the people. So the focus of the public trust doctrine was on the people and reserving it for the people, and not merely restraining the sovereign. And that led to what came after.
Thank you so much, all of you, for those insights. Now, the McBryde opinion predated the 1978 amendments to the Hawaii State Constitution, and those amendments, clearly state the public trust in water in particular, but also for all of our aina and other natural resources. How has this, this was kind of a legal evolution, begins with McBryde, follows up in the 78 Constitution that was adopted by the people of Hawaii. How has this legal evolution aligned or not with state policy regarding resource management, and what has been the effect on the ground? In other words, I'm really asking, how effective has implementation of the public trust doctrine been on the ground? And I think I'll start with Isaac, since you're on the ground a lot.
Okay. Still standing, but yes, feet on the ground. So how long do we have to talk about that? But I think the rest of the day's panels is going to talk a lot about where we are now 50 years later. In a lot of respects, we've had a paradigm shift. In a lot of respects, things are still the same, right? But as we all know, that landmark McBryde decision touched off a legal firestorm, but it also inaugurated this movement. And another mini epiphany was just looking at the history and the sequence. It was amazing how rapidly 1973 is the McBryde decision. 1978 is the Constitutional Convention that enshrines the public trust doctrine in our Constitution. 1987 is the establishment of a comprehensive water code. And I can't think of another thing that that big that the legislature has done, really, maybe ever. And that was all in the span of 15 years. And I think part of it was buoyed by the spirit of the times, the civil rights movement, the environmental movement was coming to fruition at that point, but also the democratic revolution. And sort of my question is, how do we recapture that sort of spirit, especially where now the public trust is turning towards more, or the latest pressing issues like climate change.
Right.
And Justice Edens, in some of his opinions, has made pronouncements about that, the public trust and its relationship to climate issues.
Great, thank you. Justice Pollock, do you have anything you want to add to what was just said?
I was actually hoping that Isaac was going to lead in to Iole, because I think that's the natural big step in evolution. So,
do you want to do that?
You have a whole class on that. Come on.
no, I think his closeness to that case, I think you can't conceal that. I just think that you should talk about it. And I'll add after. I'll make statements afterwards.
So all those rapid developments after McBryde rode up to a mammoth precedent-setting case called Waihoʻi Ditch Combined Contested Case Hearing. The Supreme Court issued its decision in 2000. Justice Nakayama authored that opinion. And it combined all those elements, Constitution, statute, all the way down into what people recognize as a leading case on the public trust doctrine, not just in the U.S., but in the world. Joe Sachs, the godfather of the public trust doctrine, coined the term the public trust trilogy, which includes the Illinois Central case, the original U.S. Supreme Court case protecting navigable waters, the National Audubon case from the California Supreme Court protecting Mono Lake, and then our own Waihoʻi Ditch case. So that was in 2000. Now we're 25 years later. And to your question, have things changed? I think the public trust is an accepted and settled part of our legal landscape. Everyone knows what it is. Everyone speaks that language, thinks in those terms. And then you have something like the disaster in Maui last last year, where just in a finger snap, it all wasn't unraveled, right? And I know people are going to be talking about that a lot in future panels, so I don't want to steal this thunder, but it really was a surreal moment to see how ultimately society in general, but the law as well, is so fragile. And democracy can really evaporate, in an instant if we're not vigilant.
Thank you so much. Justice Pollock, do you have anything to add to that, or?
I think Isaac is a little bit modest. He coincidentally was Justice Nakayama's clerk when that case was written. I believe, and he can correct me if I'm wrong, it is still the longest case in terms of text, pages, that's ever been published by the Hawaiʻi Supreme Court. Is that right or wrong?
I don't keep track, but it's pretty long. Yeah.
It is really long. But it's an incredible decision. It really, really is, because the public trust had been recognized. It had been adopted in our Hawaii Constitution, but the principles that allowed it to be applied had not really been set forth in a manner that said, here, these are the principles that you must apply agencies when the public trust doctrine is going to be applied. I'm going to just briefly go through, maybe just read them. It's quicker for me to read them, and I'll just give you some idea on how broad they are in terms of the principles that were established by the case. The agency has to take the initiative to consider, protect, and advance public rights. Decisions must be made with openness, diligence, and foresight. There's a duty to preserve and protect public trust resources whenever feasible. An agency has to consider a cumulative impact of the proposed use and also consider alternatives. It places the burden of proof on the applicant to show that the use won't interfere with public trust purpose. Higher level of scrutiny applied when the proposed use is commercial or private. The agency has to mitigate harm. If there's going to be harm to the resource, presumption in favor of public use, high level of scrutiny, and findings of facts that has to track what the agency did. That's all out of that case.
That's incredible.
It
Thank
really
you so,
is.
thank you so
Well,
much.
okay,
both
so
of you.
wait, hold on, I got it. So Justice Pollock is being too modest because he authored the Kauai Springs opinion, which you did mention, that compiled all those and further reinforced and expanded on that. And so it really is a process and generations of justices in the Supreme Court building on CJ's legacy.
Thank you so much. With all of this in mind, how do you see the public trust actually being implemented on the ground? What are the best steps forward that the state, for instance, could take in order to implement the public trust doctrine relating to water on the ground?
Okay. I just read and those aren't all the principles, but most of the principles that came out of Waiole. And if you think about it, all of a sudden, an agency has dual responsibility. It has to protect the resource and apply these principles and also be a decision maker. Now, that is something that has made it that the agency has not, agencies, if you look at all the cases that have gone up to the Supreme Court and how many times they've been sustaining the ruling, you'll immediately realize that the agencies have had difficulty applying the framework. And again, I think it's partly because if you think about and a contested hearing is a contest, and if you think of a contest as a football game or something like that, or there's always winners or losers amongst applicants or amongst a sports game or something like that. And I think for agencies, they think about, well, if there's only an applicant here and nobody contesting it, well, obviously the applicant prevails. Or if they're looking at something and they see, even if there's a contested issue, they take a look at it and say, oh, well, the applicant is arguing all these benefits and nobody is arguing on behalf of the resource. And that is sometimes why I believe, or often why the agency's decisions are wrong. It's hard for them to grasp what their responsibility, they have a dual responsibility. They have to protect the resource. They're the protector of the resource, and yet they're a decision maker. Now let me give you a quick analogy, because you may think that that's really unusual, and it is in one sense and it isn't in another. And as Professor McKenzie noted, I spent my first 20 years at the Public Defender's Office. So my analogy is going to be with criminal procedure for just a minute. And that is, if you think about a court and you think about a criminal case, what the court does to ensure that there is a fair trial for the defendant, to ensure that the result is reliable, something that we can trust, the court enforces certain things. It makes sure that there's a fair jury that's picked. It makes sure the jury applies a presumption of innocence. A burden of proof is placed on the prosecution, that evidence is prevented that is more prejudicial than probative, that the final verdict is done by proof beyond a reasonable doubt. In other words, it's those procedural protections that ensures we trust the result. And by the same token, the agency needs to do exactly the same thing in a sense. Remember the presumption that I read? There's a presumption with the Public Trust Doctrine. There's a burden with the Public Trust Doctrine on the applicant. There's certain things that the agency has to do in terms of investigate the facts and make sure and find. So all of those things are what the agency has to do in order to ensure that the resource is protected and the constitutional public trust provision is effectuated by making sure those principles that were articulated in Waiole are applied by the agency in the decision. If the agency enforces those procedural protections, then the decision should be reliable. But if they don't do that, which they rarely do, but I think they're getting better. I really do think it's getting a little bit better, but still it's not good enough. And I think perhaps that, I wish I had written something like that in Kauai Springs, perhaps, that maybe if the agency understood that those procedural protections are what ensures that their decision is going to be accurate and reliable, maybe they would be more embracing of those principles.
Isaac, no comments, I can tell.
Yeah, I can't add much more than that. And no, that parallel to criminal procedural protections, I think, is very insightful and revealing. I think there's a line in Waiole that talks about the agency or the trustee is more than just an umpire sitting back and calling balls and strikes, but rather an advocate for the resource and the people's rights in the resource. So I think that captures that idea. And then, in terms of what we need now, I mean, despite how far we've come, long way to go, it's the Water Commission, and current Commissioner Hannes is here. He's had a front row seat to all the travails, particularly recently. But the Water Commission has come a long way. The only, in the beginning, they only did stuff in response to litigation. They were reversed repeatedly by the Supreme Court. They were politically captured, I gotta say, honestly. I mean, I think the low point was when Alexander and Baldwin's essentially chief lobbyist, the VP, was put on the Water Commission while the Water Commission was considering Maui water cases, including East Maui. That was the nadir. But it's all like this. It's a roller coaster, and then last year was another plunge. And so I think it really comes down to what Justice Pollack said, which is the agency embracing its public trust role and not having to rely on the courts over and over again as the backstop.
I think, Professor Chang has something he wants to add.
Well, as we reach the end, I just wanted to relate something, which was the law review is putting on this symposium, and the law review had a lot to do with the Public Trust Doctrine. When I was an attorney for Chief Justice Richardson arguing the Robinson case, the law review published an article that was being banned by the opposing counsel. They didn't want to see it, because it had in it the public trust doctrine. So the law review, it goes full circle. The law review is serving the Chief Justice. The Chief Justice set up the the law school for opportunity, but also to be assist in developing the laws of Hawaii, and it did so. It's an early law review article. It's volume 2. Bambi Wild, the chief editor-in-chief of the law review, was very courageous in publishing it over the objections of the sugar company. So we ought to thank the law review for the initial start of the public trust doctrine.
Yay. Thank you, law review. I do see that we are coming to the end of our time, and so I just wanted to ask each of you, I know that Professor Chang has kind of given his final comments, but I just wanted to ask Isaac and Justice Pollack whether you have any, actually, I do have another question. You know, sorry, I'm sure you guys are going to talk about this later, but there's actually a bill pending in the legislature right now that would basically reconfigure the Water Commission. Establishes, it actually would have a purpose statement that has the public trust as the purpose. It makes it more independent from the Department of Land and Natural Resources. It will only be administratively attached. It takes off some of the appointees, changes the designation, et cetera. So I was just wondering, do you think that a new structure to the Water Commission where it's not so entrenched, for instance, with the Board of Land and Natural Resources or DLNR, would that help in implementing the public trust doctrine?
It can only help, and this bill basically incorporates recommendations that were made decades ago when the Water Commission was first formed and said, let's make this the best it can be. But it gives the Water Commission independent counsel, an executive director, and then make sure that there's going to be, like the Board of Water Supply, an elected chair that's not going to be just sort of under DLNR, because there were conflicts around that as well. So that's going to be a key measure. Unfortunately, it's stuck in the House now, and unless it gets notice for a hearing next week, it's gone.
I was optimistic because it had gone over and they had their first hearing. And
yeah, it went through strongly through the Senate. It passed the first committee in the House, and there's Representative Tarnas, the head of Judiciary Committee. It's up to him to hear the bill and keep this measure moving forward. So I think there will be further discussion about what can we do rather than just learning and hearing, and I think there's definitely action steps. One other thing to look out for is there is Commissioner Hannes' seat that's coming up, and they've had a process. The governor's about to pick somebody. This is supposed to be for a traditional and customary practitioner expert. And so, especially given the challenges from last year, what Professor Sproat in her Guardian piece called Plantation Disaster Capitalism, and I think it's a title for one of the subsequent panels. I'm really concerned about what's going to happen with this, this key appointment, but keep your eyes peeled for that one too.
okay, and so Justice Pollack, any closing remarks?
One of the things that I encourage the students that I have in the public trust class is to think about things that the court has not yet ruled upon. Even though the constitutional provision is very clear and it says that that land, water, air, minerals, energy sources are all to be protected under the public trust provision, the court has only recognized water and conservation land and beaches to a certain respect and ceded lands. In other words, they have not touched natural beauty. We have one sentence about biodiversity. We have one sentence in Justice Eden's, and I don't want to critique that opinion, but there's only one sentence it's a fabulous opinion, but it's the public trust that I think it could be more robustly protected, because the advantage of the public trust being held to protect these particular resources is we get this framework. Yeah. And that means we're going to get more reliable decisions. So that's one thing. I believe that the public trust. So those of you who are students, when you're going out to litigate, think of all the other things that we can protect. The forests, all our forests, there's no specific public trust protection that I can find. We have Zimmering that protects lava, and we have only conservation land. So I don't see the constitutional provision saying land, only certain land.
Yeah.
Nor do I see in the constitutional provision that we're going to have different frameworks. So in the second TMT case, I argued, look, we need to have a framework for everything else but water, because if we don't, we're leaving it up to the agencies to decide how they are going to apply the public trust doctrine. There's no specific principles other than in water. So those are things that I'm looking forward to, because I think we're just in the evolution of the full application of the public trust doctrine. And the more it is applied, the more future generations will have those resources protected for them.
Great. Those are great closing remarks. And with that, could you please join me in giving your mahalo nui to our
What a wonderful panel and way to start off our program this morning. Please join me in giving one more round of applause for all of our Panel 1 participants. So at this point, we'll take a brief recess, maybe 5 minutes, just for folks to go outside, reset, grab some water, and we'll come back in about 5 minutes with Panel 2. Thank you.